Good afternoon.
Good afternoon, Your Honor. May it please the Court. This is an appeal from a criminal conviction that followed a remarkably aggressive prosecution of an individual who, according to the government's evidence, misrepresented the value of the collateral of a family-owned company in order to draw more cash on a line of credit, which was never exceeded, than his loan agreement authorized. There is no claim that Mr. Rubashkin entered into a fraudulent loan that he did not intend to repay, nor was there any time until the company went bankrupt that timely interest was not paid on the loan. The scheme was fragmented in the 7th superseding indictment returned against Mr. Rubashkin into 71 counts alleging bank fraud, false statements to a bank, wire fraud, mail fraud, and money laundering. The prosecutors then added 20 counts of violating the Packers and Stockyards Act of 1921, the first ever such criminal prosecution, because cattle dealers were paid as much as 11 days late. The jury acquitted Mr. Rubashkin of 5 of these added 20 counts. In the time available to me, I propose to cover principally the failure of the trial judge to recuse herself from presiding over Mr. Rubashkin's trial, and her failure, along with that of the prosecutors, to inform the defense trial counsel of the many meetings she had with the Office of the United States Attorney and with immigration and customs officials during the 7 months when the immigration raid of May 12, 2008 was being planned by law enforcement.
Mr. Lewin, how would you state the standard of our review, or how we were supposed to review this, in that, you had an opportunity to file a motion to recuse, you had a date set, and you did not file it. Because of that, because this is, I don't know if it's unique, but it's certainly unusual circumstances, what is our review on this?
Well, Chief Judge Riley, that exactly was covered by your opinion in the Fletcher and Conoco Pipeline Company case in 2003, in which you noted that, in fact, a failure to recuse, could even be raised for the first time on appeal from a judgment. But that certainly, and your language in that case was that the time for filing that motion would be at the earliest possible moment after obtaining knowledge of facts demonstrating the basis for such a claim. And I think you said in your opinion that in that case, particularly if there was no ability on the part of trial counsel, they could not know the facts, then they had no obligation, and it could not be expected that they would move to recuse. And that's exactly what happened in this situation. In fact, the record has the affidavits of both trial counsel. Unfortunately, they're not in the appellant's appendix. That was an oversight, but they are clearly in the record. And both of those affidavits state that neither trial counsel had the slightest inkling that what was involved in this situation was the judge engaged in what ended up, from our count, from the documents that were shown by the Immigration Service, being at least 12 meetings with the United States Attorney's Office and possibly, in some of the cases, with Immigration Service personnel as well.
Excuse me, counsel. Were you aware that before the expiration of the time frame for filing for recusal or filing a recusal motion, that someone else had made such a motion to the judge based on similar facts that you allege?
Judge Smith, they were not similar facts, if I can just correct that. There was a motion made to recuse based on the facts that were known at the time. The facts that were known at the time were, one, that a Department of Justice official had stated in a House hearing that the judge was given a, quote, heads up. The judge herself had said in response to the motion that she was only involved in logistical coordination in order to be sure that she would be able to conduct trials immediately of the people who were arrested in the raid. No one, but no one, had any idea until July of 2010 that the judge had met not on one occasion, not on 5 occasions, not on 10, but indeed at least 12, as I said, with the United States Attorney's Office to discuss subjects that, according to the Immigration Service documents, included charging strategies, included her request to have a game plan, a final game plan with regard to the raid, various subjects that went far beyond the logistical coordination that she said she was involved with. And again, trial counsel have said that in terms of what they were informed of at the time, they didn't think there was a basis for any recusal. And these, again, established members, respected members of the bar, they said that had they known the facts, one of them says they would have had no choice but to file a motion to recuse, and the other says he would definitely have filed a motion to recuse had they known the facts that were disclosed in July of 2010. And I will tell the court...
How does that affect, because all of that goes to the investigation and the arrest of the undocumented aliens and your trials on the bank fraud and the money laundering. So how does that, I don't know, I hate to use the word prejudice, but how does that affect the case that was actually tried about what was done with regard to the judge's involvement in trying the aliens?
The government's theory throughout its prosecution was that the person in charge of the agri-processor's plant was Sholom Rubashkin. He was in control. That was a main point at the trial. At the very outset of these various conversations, the government attorney said, we will, to the Immigration Service, we will prosecute agri-processors if we find a basis for pursuing them. There's no question that from October of 2007, the United States Attorney's Office was aligned with the Immigration Service against agri-processors, whom they said was a likely target and a likely subject of prosecution in the case. Mr. Rubashkin, shortly after the raid, was given a target letter. He was told, he's given 2 target letters, as a matter of fact, but told almost immediately.
I have not seen those, but was that related to the undocumented aliens, or was it related to any type of bank fraud or money laundering?
The first target letter was related to the undocumented aliens. The second target letter, to my recollection, was related to both charges, to the bank fraud as well.
And when you say the second one, what?
He received 2 target letters. The U.S. Attorney, Mr. Rubashkin, was given 2 target letters by the government, and the second related to both. And
when was that in the sequence?
Well, I just don't recall the exact months, but the first one was in May, shortly after.
But give it just for purpose of context, roughly what's your memory say when that occurred?
I think it was several months after the first one came, a second letter. It may have been in November, or September, October. I'm not sure the exact month. But it was several months thereafter when he was given a target letter which related to the bank fraud as well. He was indicted. He was arrested on the bank fraud within 2 weeks after he was initially arrested on the illegal alien charge. So the bank fraud and the allegation that he committed fraud on the bank by misrepresenting in a large document, a loan agreement, in the course of it, in there, that the company was not violating laws, was something that was presented early on. And the point is, again, let me come back to the fact, Your Honor has asked, why is that relevant? It's relevant because under the standard, the applicable statutory standard, 455A, the appearance of justice is what is the key. Would an ordinary person in the street say that a judge who had participated in planning a raid on this company, the chief officer, operating officer of which was subsequently charged, indicted, first on immigration charges, then on bank fraud charges, that she should be presiding at his trial? The question is that the appearance of partiality? And we submit that to any person who is asked, and from the time in July of 2010 that we discovered these facts, I can only say that there is, quite frankly, telling the court, no person whom I have asked, or I think anybody on the defense side has asked, who does not say in shock, the same judge who participated in planning the raid presided over the trial of Sholom Rubashkin?
What evidence are you aware of at this point that the judge helped plan the raid? And what do you mean planned the raid?
Well, again, there was no evidentiary hearing. We go on the basis of the documents that appear in the appendix.
Freedom of Information Act documents?
Pardon?
Your Freedom of
Information Act documents, correct. And there are a substantial number of them which give rise to the implication that the judge was involved in more than logistical cooperation. The judge, statements that the judge has made, now these are discussed in our briefs, the judge says, I support this initiative. It's called an initiative at various times. She expresses support for the initiative. She is
but the rest of that phrase, and I don't have it in front of me, that's taken somewhat out of context. I don't know if you have it in front of you, but she goes on, it's wherever it is, in support of, I will support you, including, and what the including phrase is.
Judge Riley, there's two statements of support. One is at Appendix 269, a meeting of October 17th, which is 7 months or almost 7 months before the raid, at which she says she indicated full support for the initiative. That's when she was asked where she was going to be, and she said she would be out of the country.
The initiative at that time was involved in how many officers they would have to have there, or interpreters or something. It was related to the immigration charges that...
The initiative was the raid on agri-processors, Judge Murphy. Yes, it was the raid on agri-processors. That is why she was contacted. The question was, when should we do the raid? When will you be there? And she said at that very meeting, it's Appendix 269, she would be out of the country and unavailable for all of February and half of March 2008. They were coordinating the date of the raid with the date when the judge would be available. That was the first statement of support. Later on, she said on January 25th, 2008, she said at a meeting where other people, other law enforcement officials were present at her request. The document says at the request of the judge.